Hello and welcome back to the video updates. Today's video is going to answer a question about child support and what happens when the person paying the child support, usually the non-custodial parent, dies. So of course, child support is very common and a lot of people have the child support already ordered by a court. So this video is speaking specifically to the child support that's been ordered by a court, not an informal arrangement between the parties. So when the child support is ordered by a court, typically the non-custodial parent will be paying monthly to the other parent or twice a month, depending on whether the payment is being made directly by the employer. So that's what they call income withholding. So the employer would be able to pay to the child support office directly for the custodial parent. Now, when the non-custodial parent falls behind on the child support payments, it goes on for a little while, and then eventually that child support office is going to issue a judgment of arrearage. So child support arrears would be put inside that judgment, the amount will be specified and the date, but of course that would change over time if the person continues to fall behind on the child support payments. And some of the time, the child support offices would also file a judgment lien or an abstract of judgment inside the official public records in the county where that person lives, or in a couple of counties, maybe within the adjoining areas. And the reason they do that is so that the child support lien can attach to assets that the person has, such as real estate. And eventually people do sell their real estate. So at that point, the child support lien would be paid directly by the title company. They must pay that in order to be able to close and sell the property to a third party. So the system actually works pretty well in that sense that most people end up having property, and child support is not going to be one of those liens that you can easily avoid. So what happens then if the person paying the child support dies? Maybe they die young, maybe they die a little bit older, but for some reason they were already behind on the child support payments. Or let's say they're not even behind on the child support payments yet, but have an ongoing obligation. Typically, the child support order says that the obligation becomes the obligation of the estate if somebody should die that was ordered to pay child support. If the order doesn't even say that, most courts would find in favor of the custodial parent if there's ever a dispute as to whether the child support obligation continues after somebody dies. So even though that person doesn't have any income that they're generating at the moment, it's possible that they have assets that the court could use to satisfy the child support payments that are due, on an ongoing basis. And they could calculate that amount because the amount is usually fixed inside the court order. And even if it changes because one child graduates, high school, the amount can still be figured out. So they can come to some sort of an amount that they would have to pay to the custodial parent to satisfy the obligation that was ordered. So that's how it works. Now, if there was a judgment lien already filed, a child support lien already filed inside the property records or the official public records, then of course it makes it even more difficult, and it's the same treatment that it would get. So if somebody dies, it doesn't mean that the lien automatically expires. It just means that the executor of the estate or the administrator of the estate or the personal representative of that estate, that's the party that's going to have to sort that out and satisfy that debt. Of course, some estates don't have any assets at all that could be used to satisfy creditors. And at that point, yes, it will be written off. It doesn't become a debt to the heirs. It's just the debt of the estate itself. So that is the quick video that I wanted to bring today to clear that up. The child support liens are very unique. They don't expire, they don't die, they really don't go away unless there's just no asset at all at the end of that person's life and there's no way to pay the custodial parent. If the estate doesn't have any funds to satisfy the creditors, then it probably doesn't have any funds to satisfy the child support amounts owed as well. So at that point, then yes, it will just be written off because there's nothing to satisfy the debt. The heirs of the deceased non-custodial parent are not responsible for the payments, just the estate itself. So I wanted to make that clear. So it really doesn't quite go away. It doesn't go away in bankruptcy. It doesn't go away because somebody moved from state to state. You know, they have ways to track these things. And it does not go away just because somebody died. It doesn't even go away just because the custodial parent dies. And I'm going to cover that in a second. So I wanted to just emphasize that it's important to try to take care of it now. Unless, of course, you think that, unless, of course, you know, the person really believes that he or she is not going to have any assets whatsoever at the time of death, then of course you can ignore it. But I have to say that we've seen some cases where the child support was owed for so many years that the custodial parent actually already gave up every hope of ever being able to collect because she didn't even realize that he survived death, right? The particular case that I remember clearly, it was a few years ago, but the children that were actually mentioned under that court order had already turned 40 and 50. So the order had been there for a very, very long time. The custodial parent never got any money after the first couple of years, and so she pretty much gave up. But guess what? The child support office had filed a judgment lien inside the official public records, and of course the non-custodial parent owned real estate, which was ultimately sold. He had died for a few years, but the heirs didn't do anything about the property for a while, and the only people that got stiffed in that equation were the children, you know, the heirs, because they thought they were going to get huge chunks of money from the sale of the property. But it turned out to be that the ex-wife, who had patiently waited to get paid for this child support that was ordered by the court, she was first in place because the lien is going to be satisfied off the top of the sales proceeds. So I represented that custodial parent in that scenario, and I was able to submit the up-to-date judgment amount to the title company, and the title company definitely honored that and paid the total amount. And she was so surprised and she was so happy that this was happening after so many years of lost hope. So this just to remind people that you might be able to hide, but you cannot run away from this particular type of obligation. And sometimes it's your heirs that are going to suffer the consequences because your estate is going to be reduced by the amount owed on the child support. So that is what I wanted to cover in this particular video. And the other related question is, what then happens if the custodial parent is the one that actually died, not the non-custodial parent? The custodial parent can die sometimes, and yet the estate of the custodial parent would be the one to step in and collect that child support debt. Remember, it's almost the same. We just flip the equation around. And so in this case, the custodial parent will be deceased. The executor of the estate, if there is a will, or the administrator of the estate or the personal representative of the estate will be the one to step up and enforce that child support judgment that was already owed. And then if there is no will at all, that means most likely there's no executor of the estate unless there was a probate case opened, and then maybe there's a personal representative for that estate. That person will be the one to be able to step up and collect on the child support that's back owed. However, if there is nothing at all, then the heirs can jointly request collection of that debt. So the heirs would inherit from their parent, the custodial parent, because the custodial parent did not have a will. And so we would use the intestacy laws, which will be the default, laws of that state. And then the law would usually say that the children would get anything that's owned by the estate. So in that case, that is debt owed to the estate. So they will be able to step in and claim that money from the non-custodial parent. They'll be able to step in and claim that money from the non-custodial parent. So that's how this whole thing works. It varies slightly from state to state, but typically, even if the court order doesn't mention death or doesn't mention that the child support survives death, the courts generally would interpret it that way because common law interprets it that way as well. So I would say if you have a question specific to your situation, definitely consult with a lawyer before it gets completely out of hand, because sometimes you might be able to negotiate, because sometimes you can actually negotiate the amount down. The non-custodial parent probably already gave up hope a long time ago, so they'll be happy to get anything at all because the amount is going to be quite huge right now. The amount is going to be such a big amount right now because so many years have passed. So they'll probably settle for a little less than the total amount if you really negotiate hard. So this is what I wanted to cover today. If you like the channel, remember to hit the subscribe button and click on that bell so that you can continue to get notifications of upcoming videos. And if you like this particular video, please do give us a thumbs up. I appreciate you watching as always, and I hope you have a fabulous weekend, and I'll be talking to you next time.